This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we're now joined by the one and only Todd Lutsky here for a little segment we like to call Ask Todd. If you've got a question for Todd Lutsky, studio lines are open at 888-205-2263, so get calling to make sure you get in line to ask Todd your question. That phone number is 888-205-2263. He answers them right here on air. So one last time, that phone number is 888-205-2263. Mr. Lutsky, how are you today?
I am never better. And you?
Bit of a problem.
There always is with you.
New year.
Yeah.
Get a new little wall calendar.
Yeah.
Someone took the 5th month out of it.
Yeah? Why?
I don't know. I'm dismayed.
It's definitely dismayed.
It's a real problem. Todd, I want to talk a little bit about some real basics when it comes to estate planning. And I know we get into, you talk about some complicated trusts and things that, are complex sometimes. I want to just talk about wills to start things off today.
Okay.
When you look at the ideal way that a will should function in someone's estate plan, what role should it have, or should it have any role?
The way I'm going to interpret this question, and tell me if I'm wrong, Chuck, is the way I think about it is, and many people think this, if I've got an estate plan done, meaning I've done a trust and some of the big heavy lifting documents, why do I even need a will? That's kind of like what you're asking, but indirectly, right? What's the role of a will if I've got an estate, if I've got a trust in place?
Or, hey, in what situations is a will enough for an estate plan?
Rarely, I would say a will is enough for an estate plan.
Okay.
I would say that to me, if you're going to do nothing else, I guess you do that. That means when I say nothing, I mean a will won't help you avoid probate or reduce estate taxes or protect assets from a nursing home or any of those things. So if you don't care about any of those things and you just want to make sure that your assets go where you want them to go, well, then I guess a will would be enough. So when I say rarely, that's what I mean by rarely.
Sure.
But I think, the way I look at it, too, is I get a lot of these questions, Chuck, which is, why do I even need one? Well, there's quite a few reasons, actually, even though it's not the most important document. It might be if you have minor children. If you have minor children, it is the document that names guardians. I think that's a pretty important reason.
Yep.
To have an estate plan, or have a will, rather. So definitely if you're a minor child, have minor children, you need a will to name the guardian. Next. All right, Todd, a lot of our clients don't have minor children anymore. They're all grown. What's the will do? Well, the will actually directs where your tangible personal property goes. That jewelry, the fishing poles, the Hummels, the stuff, if you watch American Pickers, the stuff you would find what they find when you go in the... Where do you want to give this stuff to? Put together a list, describe the item, say who you want it to go to, and attach it to the will. That's important, can be for a lot of people. Lastly, and maybe most importantly, even if you have a trust, people travel, right? We move, we live life. We don't die after we do our estate plan. And we put all our assets in the trust, and then we go out and we open up a new bank account because we, maybe move to another state or another city. And you forget, you naturally open it up in your own name, not in the name of the trust. Common. Well, now it's not in the trust, right? Well, what about if I actually moved? I might just buy a new house or a vacation home in another state. How are you going to buy it? You don't think about it every day. You just buy it in your own name. That's normal. Well, if you do that, now it's a probate asset. It's not in the trust. You could be probating in 2 states. I get it. But at least with the will, it would be a pour-over will, different than a simple will, that would direct the asset to go to your trust. Why is that critical? Even if you died and you didn't avoid probate, I know, but at least the asset gets in the trust, which is where you want it, for 2 very important reasons. One, to direct how it gets to your family members, or who gets it and what fashion and when and why, and maybe protected from creditors, etc. And it's going to be sheltered from estate taxes. If you put it in there, it'll be able to get into the bucket it needs to, that remainder share, that marital share to shelter it for estate taxes. So you might not think a will's important, but you still need it, even though you've got a trust in place, folks.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. If you've got a question that you'd like to ask Todd live on air, our phone number here is 888-205-2263. That number again is 888-205-2263. We're going to take a quick break here, but when we come back, it is going to be right to your phone calls. So, again, get in line. We've got a little bit more space here if you do want to call in. That phone number is 888-205-2263. One more time, it is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Todd Lutsky answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
All right, Todd, we got a few callers for you. Let's go first to Bernie in Canton. Bernie, you're on with Todd Lutsky. What's your question?
Yes, hi. I'm calling about an irrevocable trust. I have my house in the irrevocable trust, but I understand that the IRS has made a new rule that when the kids inherit the house, they don't get the step-up in basis, and they have to pay the capital gains on the whole amount.
Great question, and the long and the short of it is, and this came out a year ago, so we were all over this when it came out, and it is so misleading for the general public. Okay, first and foremost, I can assure you that for you, if you are worth less than $13 million, likely you didn't do the kind of trust that this revenue ruling is addressing. So remember, there are many kinds of irrevocable trusts out there, folks, but this irrevocable trust that's addressed in this particular revenue ruling is one in which you would have given away the asset and not retained any real interest. It would not be included in your estate when you die. It was a complete outright gift. That's true. That's not new. That's how it's always been. So if you make a completed gift to get assets out of your estate, then yes, you give up the step up in basis and you trade that off to save on the estate tax world, which remember, between federal and state here in Massachusetts could be 50%, and the capital gains tax rate by losing the step up in basis is 20% at the federal level anyway. So, that's the trade-off, and that's generally something that's analyzed when you do this. So good news for you, Bernie. And for many of you, especially all my clients that have done Medicaid irrevocable trusts, it does not apply to you because that trust is designed to have the asset included in your estate when you die. You keep way too much control over those assets in that type of irrevocable trust. And so therefore, you will still get the step up in basis at death. And this revenue ruling really changes nothing. So hopefully that is clear for many of you out there listening. And it was troubling because it is misleading for a lot of people who are not in the estate tax world. Folks, what also can be misleading is understanding estate planning, right? This guide we're giving away this month is back to the basics. It is all about education, which this revenue ruling was not helpful in doing. It is going to educate you as to how to get started. One of my favorite guides as we approach the end of the month. It's basically my recommendation to a hypothetical estate planning client to say, here's what I recommend based on the assets and family dynamics that you have. Put your own family dynamics into this, your own assets into this, and you can see whether this recommendation is right for you. If not, it will nevertheless explain to you, educate to you how a will, a healthcare proxy, power of attorney, living will, and trust operate to create an estate plan, and it'll get you off the dime. If you've never done estate planning, this might get you started. One of my favorites, call and get it, 866-848-5699. or legalexchangeshow.com. You can download it right there. Again, as we approach the end of the month, 866-848-5699 or legalexchangeshow.com.
Todd, I got another for you here. Let's go to Jerry. Jerry, you are on with Todd Lutsky.
Good morning.
Morning.
Question for you.
Sure.
If I do not have a house in my name and most of my money's in an IRA,
Mm-hmm.
I do not believe you can move the IRA over to the trust without paying taxes.
Yes. Well, are you married?
Widowed.
Widowed. Okay. So you're right. I mean, if you don't have a house, and it sounds like your biggest asset is what you're telling me is your IRA.
Yes.
Yeah. You put a designated beneficiary on it. I cannot move it into any kind of a trust. By the way, you cannot move it whether it's a revocable trust or an irrevocable trust. You just can't retitle it to a trust. Why? Individual IRA, right, folks? That's what it means. It's your individual account, and it has never been taxed before at the income tax level. So in order to move it, it would have to come out of the IRA, be subject to income tax, and then you could transfer the money into any kind of trust, revocable or irrevocable. But unfortunately, if you take a large chunk of money out of an IRA, you could lose up to 40, 50% in taxes. So not a great idea there.
Todd, we got one more queued up for you here. Let's go to Leanne in Plymouth. Leanne, what's your question for Todd Lutsky?
Hi, good morning, Todd. So I am 50 years old. I own my own home.
Mm-hmm.
I have a savings account, IRA, brokerage account, 401k.
Mm-hmm.
I have one daughter,
Mm-hmm.
and she's the beneficiary for the IRA, the brokerage account, the 401k.
Okay.
When do I get a will and a trust? If I'm 50.
Are you married?
And I have the one. I'm not single.
Go ahead.
When would I do a trust or a will?
So,
and if she's the beneficiary for everything, because it's just one daughter.
How old is
do I
she?
need all of that? She's 20.
Yeah, so she's kind of young. I don't know how much you're worth, but the first question I have for you is, if you died tomorrow, do you want all these assets to be dumped in her name? Is she able to handle the money? Is she good with money, and you're not worried about any
Definitely.
creditors or anything? Okay. So if that's really the case, then you can set up the designated beneficiaries the way you did it. It will then automatically pass to your daughter. It will avoid probate. Obviously, it's subject to estate tax, but if you're under $2 million for mass, there won't be any. Now, if you have a home, which you said you do, the home, unfortunately, will go to probate. So you will have to force her to go to probate because you can't really, and you should not really just throw your daughter's name on the house. I don't think that's a great idea from a tax strategy standpoint or a creditor protection standpoint or anything. I just want you to be in control of your house. So I wouldn't do that. So you're probably going to have a probate issue with the house. But, the bigger concern is, again, only 50, certainly I would say a little on the young side to be thinking about long-term care. But as you get older, there might be a reason, right? You might want to say, well, geez, if I really want to make sure these assets are available for my daughter when I pass, having them set up just with designated beneficiaries on, while we'll avoid the probate process, will do nothing to, protect them from the cost of long-term care and protect them for her, so that they will be there and not unnecessarily depleted if that becomes a concern for yours. Then, of course, you would want to be thinking about the irrevocable trust. Now, and I know it didn't sound important to you, but in speaking to the general public and hopefully educating them on this answer, the other reason I don't love what you're doing is because, your daughter is only 20. I mean, I've got children that age. I know I would never want to dump, and I don't know how much you're worth, the money in their hands. It might be better to think about long term. Maybe, depending on how much it is, of course, she might get married and then have children. And then by the time you get around to dying, you could be leaving a bunch of assets that hopefully will grow over time to her. And then she gets divorced 2 years after you die, and there goes the money. So, sometimes having a trust in place to protect assets from themselves is not a bad idea. So to simply avoid probate, I think you've got it covered except for the house, but I might think that you just want to consider even a revocable trust might not be a bad time for that.
Todd, appreciate you taking the time today. Thank you so much.
Always my pleasure. Thank you.
The views expressed in this segment are solely those of Cushing and Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. If you've had a successful career and want to make sure you protect your assets, now's the perfect time to create a plan that will allow you to enjoy your retirement years. Cushing & Dolan's new guide is called Back to the Basics, a complete guide to an estate and asset protection plan. And in it, you'll get educated on important issues like how to avoid probate, passing your assets along to your family, and potentially eliminating your estate taxes. Don't wait. This free guide has all the information you need to build a safe and secure estate plan that will give you peace of mind as you close in on retirement. Call 866-848-5699 right now and request your free guide today. You can also request a no-obligation consultation to review any current planning you've done. Cushing & Dolan have been helping families like yours for 30 years. Let them help you too. Get their new guide called Back to the Basics today. Call 866-848-5699 or request the guide online by visiting LegalExchangeShow.com.